So, Stephen, welcome back. Today, we are going to walk through asset protection planning. We really want to talk with those high net worth, high net worth individuals who want to be shielding their wealth from lawsuits, from creditors, from predators, and those types of things. So, let's set the stage for everybody. Uh, really covering who needs to know this and why they need to know it right away. Um, where you are, you've worked with aerospace engineers at Kennedy Space Center. You've worked with physicians, real estate investors across Brevard County. What do these people have in common that makes asset protection so critical for them?
Yeah, asset protection is I really love the asset protection conversation because there's so many nuances to it. But for those people, they usually have about three things in common. One is they have assets. They have good paying jobs. They accumulate assets. They also often are in more sort of liability type exposed areas. Physicians, of course, they often have a bullseye on their back if something goes wrong medically. Um, a real estate investor, you have tenants, you have maybe people, construction people who come to work on the house, or just, people who come in and see their tenants. Or there's certain liabilities with business owners, the aerospace engineers that they have employees and they have customers, of course. And the third thing is that they're all busy, right? So they all push this off, this very important conversation, until sometimes it's too late.
Okay. And a lot of high net worth individuals may think, well, I've got good insurance. I'm covered. What's the flaw in that type of thinking?
So insurance is great. I mean, insurance is always your first line of defense. But a few things to know about insurance is that number one, insurance companies really don't like paying out claims. They will look for what is the exemption on page 37, subparagraph double Z, in order to give them an excuse to not to pay. The other thing is that they often have liability limitations. So if it is a catastrophic event, and God forbid there is, a car accident where a person passed away, um, that's going to blow through that $1 million very quickly.
Hmm.
So that's often a hole that is there that you can't just rely on insurance as a blanket of liability protection.
So we are lucky here in Florida. We do have some built-in advantages. And it has the state has a reputation as one of the most debtor-friendly states in the country. Walk us through some of those advantages: homestead protection, tenancy by
Mhm.
entireties, and retirement account exemptions. What do those three actually shield?
So the biggest one is the homestead protection. So under the Florida Constitution, so that's very strong, of course, is that your primary residence is fully protected from creditors as long as you pay your mortgage, pay your taxes, pay the construction lien, someone who comes to fix your roof. Um, Besides those categories, no one can touch your house. Okay. So what I often tell people is that that's why OJ moved here, that he was able to put a large amount of his money into a very nice residence down in Miami, and it frustrated the Brown family for until I think fairly recently. Um, and so that is fully protected. Next one is tenants by the entireties. That is a special designation that we have here in Florida for a married couple. Okay, so if there's an asset titled as joint tenants by the entireties, a individual creditor of of the married couple cannot reach that asset because it has that special protection. And then the retirement accounts. Retirement accounts, where they're a bit unique as well, is that not only is your retirement account protected from creditors, but if you pass away and it rolls over to your spouse, that's also protected. Okay. So that's protected both by federal and state statutes. Where it gets a little bit trickier and where Florida again has an advantage is that if it becomes an inherited IRA, then your beneficiary, as long as they live in Florida, because we have a statute that gives it asset protection, that has asset protection. But there's a U.S. Supreme Court case that a few years ago that said, if you didn't work for it, we're not going to give you the protection. So federally, that inherited IRA does not have protection. Or if your child is in a different state, that may or may not have protection based upon that state statutes. But here in Florida, that inherited retirement account is still protected.
We talked a little bit now about LLCs. At what level of wealth or risk exposure does the conversation shift from LLCs to irrevocable trusts or domestic asset protection trusts? And what is actually different about the protection that those offer?
So a lot of it comes down to the ownership. Okay. So with the irrevocable trust, you no longer own the asset, the trust owns it. Whereas in LLC, you have more ownership, you have a bit more ability to touch the asset. Okay. So they do two different things, and they have different layers of protection based upon what your different goal is, where you're trying to achieve. Okay. So sometimes the client wants more of the control, more of the ability to touch the asset. And so therefore we may do a family LLC or a family partnership in order to do those things. And maybe for tax reasons, the state tax reasons, why we utilize the irrevocable trust. So it's based upon the goals of what we want to do, or it could be for those who have between $1 and let's say $3 million in assets, but they're older, they want to protect themselves from a nursing home. Then we sometimes utilize irrevocable trust for those people, in order to protect their assets from a nursing home situation. So it's based upon a lot of different factors on which kind of lever we pull. But that's why we have that discussion with our clients. We discuss what their goals are, what their comfort level is, and explain to them the different ways that we can achieve those goals. And then from there, we as practitioners, we can provide them with the best options, but they have to live with it, right? So they have to live with the irrevocable trust or live with the LLC and all the pluses and minuses that go with them. And so we have that honest discussion with them so they can make an informed decision.
Okay. And let's just get really specific and maybe quickly list out some of those things, because that phrase irrevocable trust can make people nervous. It sounds like, oh gosh, I'm giving up control forever. Just really quickly again, list what do they actually retain and what do they genuinely give up?
So I'm going to give you a very lawyerly answer and say it depends.
Mhm.
Because the fact that it depends upon what we're trying to achieve. If we have less than $15 million in assets, so we're not worried about the estate tax, it opens up our what our abilities are. Okay. So it could be you can change the trustee, you can hold what's called a power of appointment, which means that you can change the ultimate beneficiaries. You may be able to have access to the assets, but under certain restrictions like health, education, maintenance, support. Depending upon what we do, we may or may not have the person as a trustee. It's often better not to have yourself as the trustee for asset protection purposes, but sometimes, we can do so. We can often have them have a say in what the investments are. Okay. So they may not have direct access to the principal anymore, but they can have access to income and they can make decisions on, what the assets are. Let's say they have rental property in that trust. they can sell that rental property, invest in Applestop or Nvidia or whatever it is. So they still have a bit of control, even though it's in an irrevocable trust.